Let's talk about something that affects every single one of us, our access to justice. Today, I want to break down a fight in Congress that's flying under the radar, but has huge consequences for anyone who wants to hold the government accountable. Representative Maxine Dexter from Oregon just called out the GOP for what she describes as a wholesale attack on our right to challenge the government in court, especially when it comes to environmental decisions. She started by thanking everyone who showed up to testify, and made it clear, Oregon communities are living with the real consequences of federal decisions on natural resources, justice, and accountability. Their voices, and honestly, voices like yours and mine, matter in shaping fair policy. Now, here's where it gets interesting. There's this law called the Equal Access to Justice Act, EAJA for short. Dexter explained that EAJA levels the playing field, giving regular people and small groups a fighting chance when the government screws up. Imagine the government breaks the law, you take them to court, and you win. With EAJA, you can actually recover your attorney's fees, so you're not left bankrupt for standing up for what's right. That's huge, because it discourages government overreach. But here's the thing, EAJA isn't just for one side or one kind of issue. It covers veterans, people on Social Security, disability advocates, tribal nations, even industry groups and environmental organizations. If you win your case, you can get help with legal costs. If you lose, you get nothing. That means the law only rewards legitimate challenges, not frivolous lawsuits. So, this idea that EAJA is being abused doesn't hold up. Dexter took aim at Republican critics who are especially fired up about environmental lawsuits. She pointed out something important. Most EAJA awards actually go to veterans and Social Security cases, not environmental groups. Calling out just one group, like environmentalists, sets a dangerous precedent. If you start stripping away access for them, who's next? Veterans? People with disabilities? This isn't just about the environment, it's about whether all of us get a fair shot in court. She didn't mince words. Current Republican reform efforts are a direct attack on court access, especially for low-income and rural folks. Watering down EAJA only helps big corporations and powerful industries. Meanwhile, regular people, the ones who need justice the most, get locked out. That's not just unfair, it's unacceptable. And if you actually care about stopping abuse of the legal system, there's a better place to look: SLAPP lawsuits. Dexter highlighted what happened after the Standing Rock protests when Energy Transfer sued Greenpeace, not to win, but to silence them. That's the kind of abuse lawmakers should be fighting. Here's the bottom line. If we want a country where the underdog can stand up to power, we can't let anyone gut the Equal Access to Justice Act. This is about fairness and keeping the courthouse doors open to everyone, not just the rich and powerful. If you want to stay in the loop about how Congress is messing with your rights, hit subscribe. I'll keep breaking it down every step of the way.
Thank you, Mr. Chair, and thank you to our witnesses for coming and testifying today. I'd like to extend special appreciation to the Oregonians here, Professor Rolfe and Mr. Joseph. Thank you both for coming. It's always a lovely day to have Oregonians and natural resources. The Equal Access to Justice Act, or EAJA, as we have been talking about, promotes fairness in the court system by helping a single person or small group of people take on the federal government. EAJA helps ensure that regardless of income or power, the American people can hold the federal government accountable and in limited circumstances be spared the financial burden of government error. These actions not only give Americans a voice in the courtroom, they also deter future government misconduct and federal overreach. Stakeholders from across the political spectrum have used EAJA. Veterans, Social Security recipients, individuals with disabilities, tribes, industry, and yes, environmental groups have all recouped attorney's fees in cases where the government has acted illegally. EAJA corrects an imbalance of access to the American justice system. To get reimbursed under EAJA, litigants must meet rigorous standards to even petition for an award. The number one being that they don't get paid if they don't win their case against the US government. That's why Republican claims that the lawsuits are frivolous is frankly confusing. Cases that receive an EAJA award are by definition not frivolous. If my colleagues on the other side of the aisle are so concerned about the cost of the 11 EAJA awards last year against the Department of the Interior and another 11 against the Department of Agriculture, I'm curious to hear what they think about the nearly 10,000 EAJA awards against the Social Security Administration or the 6,000 against Veterans Affairs. In addition to my role on this committee, I also sit on the Veterans Affairs Committee. I am concerned that attacks on one smaller group could open the door to attacks on the ability of veterans to get their due from the government. It's not just me that's concerned. I request unanimous consent to enter into the record a letter from VetLeg, a nonprofit group that represents veterans. They have won thousands of cases,
Without objection, so ordered.
Thank you, Mr. Chair. They have won thousands of cases reinstating benefits to those who have fought for our country. But VetLeg wouldn't be able to take many of these cases on without the help of EAJA in recouping attorney's fees. My Republican friends have complained that some environmental groups win their EAJA cases too much. Do they think that VetLeg also is too good at their jobs and that they should be cut off from EAJA? Under normal circumstances, I would think my colleagues would never consider such a thing. But we find ourselves in unprecedented times, which includes a wholesale attack by Republicans on access to courts. If reforms to EAJA are on the table, let me be very clear. I'm only interested in good faith efforts to improve transparency or changes that would help small public interest litigants across the political spectrum get access to the courtroom. Any changes to EAJA that would make it harder for rural or in low-income communities, individuals, small businesses, or organizations to access justice is a non-starter. Reducing EAJA eligibility in that way would be a giveaway to large firms and industries when it is specifically designed to give regular people the opportunity to hold powerful entities to account. Mr. Chair, we should agree that working people should be able to challenge the federal government. Making EAJA harder to access would essentially lock the underdogs out of the courtroom. If abuse of the judicial system is of interest to my colleagues, they could focus on SLAPP lawsuits. Strategic lawsuits against public participation are frivolous lawsuits brought by people or companies with a lot of money to silence their opposition and drain their small bank accounts. In 2016, the Standing Rock Sioux tried to stand up to a massive fossil fuel pipeline proposed to go across their sacred land and over their water supply. The eyes of the world turned to Standing Rock. One of the many groups and people that were there to support them was Greenpeace. Energy Transfer is now close to destroying Greenpeace through a SLAPP suit. I would be happy to provide the chairman with other actual and egregious examples of judicial abuse. Until then, I look forward to the conversation about protecting access to the courts for working families. Thank you, Mr. Chair. I yield.